to WMMBAM.com, keyword video, for our next candidate video interview where we're going to let these candidates interview themselves. It's Brevard Public Defender candidates Blaise Trettis and Ken Rhoden. Gentlemen, thanks for sticking around after the show to do this. We're going to let you fire questions at each other. Ken, we're going to start with your question for Blaise.
I'll start with Mr. Trettis' last comment that he's never run for office before. I have here, he actually ran back in 2007 for the 2008. He was running for public defender, put $93,000 in his account, ran against a guy named Mark Randall. It looked like Mr. Randall would prevail. Mr. Trettis stepped aside and the incumbent ran again. So how can he say he didn't run for office whenever here's the campaign finance activity, Florida Department of State, Division of Elections listed him as a candidate?
Blaise, we'll let you answer that.
That was very early on before the year of election. I never qualified to run. I think I was a candidate for a number of weeks is all it was. So I was never on the ballot, and actually I made no even campaign appearances back then. I guess it was 4 years ago. There was no campaigning. I did open a campaign account. It was literally a matter of weeks, and there was no qualifying as a candidate.
Okay. I love it when you get lawyers into play because the littlest differences make a whole lot. Blaise Trettis, your question for Kim, please.
Okay. In April of 2011, Mr. Rhoden, you wrote a letter to the Florida Bar News, which is the monthly newspaper of the Florida lawyers. And in that letter, you complained about some of the things as you saw problems in the criminal justice system, and you offered some of your proposed solutions. And one thing you wrote was, quote, "Courts and attorneys fuss over the speedy trial status of a case at every hearing. A simple rule change requiring any defendant wanting a speedy trial to file a demand would save much aggravation," end quote. Now, isn't it true, Mr. Rhoden, that your proposal is for the Florida Supreme Court to use its procedural rulemaking authority to actually change the speedy trial rule so that a person would not have a speedy trial attached at the time of arrest, but would instead actually have to file a written demand for speedy trial? Isn't that true?
Absolutely not. This would eliminate one small procedural step that attorneys and judges have to spend much time and effort on in court. It would eliminate this small step. You'd still have your right to file a demand, a 60-day demand at any time. Under the current rule, after 175 days, if you're arrested for a felony, you still have to file a pleading asking for discharge, and then you have a whole nother hearing. So this tiny change in the rules saves a lot of aggravation, takes absolutely and utterly nothing away from the...
What is your proposal exactly?
Away from the speedy trial rights of the defendants.
Well, what is it? You're not explaining it. How would it work?
It would work pretty much like it does now, except that now you wouldn't have to worry about and fuss with talking about, has the speedy trial been waived every time a judge or an attorney in court touches a case.
Why not?
Right now, absolutely zero cases have been discharged in the state of Brevard County because of expiration of speedy trial rule. So it's something that would save a lot of time and aggravation and take nothing away from the defendant and be perfectly constitutional and constitutional within the federal speedy trial guidelines set by the the United States Supreme Court.
So, so you're saying that when you're arrested, you still have a right to a speedy trial under your proposal?
Of course you do.
How would it work then? What is your proposal exactly? Do you have to? You're not explaining what your proposal is. You're saying it'll be constitutional and it'll end the fuss that now exists. But didn't you also at a meeting of the Space Coast Tiger Bay tell that crowd that this was a procedural rule change the Florida Supreme could make by making a defendant have to file a written demand for speedy trial if they wanted a speedy trial?
It's a procedural rule instituted by the Florida Supreme Court. They can change that rule any way they see fit.
Is that right? To eliminate your right to a speedy trial at arrest, they can do that? You don't think that violates the Constitution?
It doesn't eliminate their speedy trial rule at all. They still have a speedy trial rule. If they file a pleading, they get a trial within 60 days.
Why, it doesn't exist now, though, correct?
Yes.
Okay, then what's the change? What is your proposal for change?
The proposal is to change, to eliminate, so that you don't have to continuously, every time a speedy trial rule comes up, a speedy trial issue comes up in court, every time a court touches a rule, touches a case, to eliminate that portion of the rule which says that you get, after 175 days, you have to file a pleading. So, yes, you would file a different pleading.
What would that pleading be?
That would be a 60-day demand. You get a trial
Wait,
at any
you
time.
already had 175 days speedy trials up. Now you're saying you have to file a demand for a 60-day speedy trial. Is that what your proposal is?
You have to file a pleading of some sort, yes.
What's it called?
Well, it would be a request for trial.
After 175 days, when your speedy trial is already run, you'd require the defendant to then file another demand for a speedy trial because that time is up. And right now, the 175 days is the limit?
No, Mr. Trettis, you need to read the rule. I know you don't litigate cases in court, and you haven't litigated speedy trial or federal speedy trial issues like I have. So you need to read the rule. And the rule is very clear. If you take out one or two lines of it, I know that you can't hardly stand to take out or make the rules
what
simpler.
2 lines will you take out? That's what I'm looking to hear because you haven't explained that.
Okay, well, I have it. The very first part of the rule, there's a provision that whenever you have a case, you get a trial after 175 days, but only after filing a pleading. You could go for years sitting in the jail, and if you don't file your motion, you don't get a trial. So that's what I would change.
All right, Ken, another question for Blaise Trettis.
What budget method does the public defender currently use, and if elected, would you continue to use that method or switch to something else?
The budget method is that the budget is $7.8 million, and it is the public defender's authority to decide how to spend that amongst the office. So there right now is a history of starting salaries and minor pay increases when
no,
the
we're
legislature
talking about
authorizes
we're talking about budget method. I know you don't have any actual budget experience,
well, that's not
but
true,
do you
but,
even know do you even know what budget method the public defender currently uses? You've been there for 19 years.
I have not been involved in the budget at the public defender's office because that is entirely the function of the elected public defender, and I think your listeners could understand that is the elected public defender who's responsible for the budget. Now, when it comes to budget, I have been basically telling attorneys for the last 19 years of what their pay increases have been decided by the public defender. So if you think that it's a smart thing to let an elected public defender, a constitutional officer, transfer that budget duties to an assistant, I totally disagree with you.
Well, the budget method that y'all use is called the historical traditional method, and I would go to a zero-based budgeting system because I would look at every expenditure every year. So I'm glad I can educate you on the functions of the public defender's office.
All right, Blaise Trettis, another question for Ken Rhoden.
Okay. In your literature, you write that, quote, he will use paralegals where possible at half the cost of attorneys. Clients will pay back the full cost of services with payment plans or community service, end quote. Isn't it true, Mr. Rhoden, that the public defender does not have the authority to order its clients to enter into payment plans or do community service? So the public defender doesn't have the authority to do any of that. Isn't that true?
It's called leadership. If you lead in the office and get the judges on the same side of collecting these fees, then yes, with leadership, absolutely, you can get them to impose community service as the statute provides for, or to make it a condition of their probation or community control that they pay back the full cost of services. So with a little bit of leadership, to quit spending so much taxpayer money and to try to have the actual clients using these services pay back what they use. Yes, with that leadership, absolutely.
So you'd have to convince other people to do something. That's not something the public defender could do, is order a client to enter a payment plan or pay a certain amount. And isn't it also true that under the existing system that raises $1.9 million in attorney's fees per year, that those costs are paid back during probation? Isn't that true?
Yeah, sometimes they are. But you can also do lots of other things by having them do community service. You can also have them pay back following the representation. There's a whole statute on how you can collect fees, which is not being utilized. And yes, I make a living persuading judges or asking judges and convincing judges that the right thing to do is to do this or that. So it's nothing unusual for me to sit down and talk to a judge. I appear in front of these judges all the time to do this or that.
Well, if the current system raises $1.9 million per year for the 18th Circuit alone, you're still saying that the system isn't working when it's a condition of probation, that these are paid off? And wouldn't community service actually allow someone to just pick up trash on the beach and instead of actually pay money?
Well, if you convince a judge that you don't have the money, then doing community service does two things. One, it gets some community service done, and if you're going to have to actually do some work, it's going to convince that person to find the money. So yes, we will change the behavior of the people by changing the policy of government, which certainly is a very easy thing to do.
Gentlemen, out of time in this video segment, but thank you both for coming in. Appreciate it. It was a spirited debate. Good luck to you as you move forward in this primary season. Thanks so much.
Thank you, Bill.
We'll see you back here again at WMMBAM.com. Keyword video, more candidates coming soon. Join us right here.